Mrs. Lee. My ladies, my lords, just before I go back to Vaux and the submissions I was making just before the short adjournment, it was drawn to my attention during that adjournment a point in respect to the guidance that I referred the court to. I referred the court to the guidance at Core Volume 2, page 160, MS 8934. That is dated 2013.
There is more recent guidance.
There is more recent guidance. It doesn't say it supersedes the earlier guidance. The relationship between the two is completely unclear. In those circumstances, I'm going to leave it to Dr. McGleenan to explain what is going on between the two guidances. But I just wanted to draw that to the court's attention. So, going back to Vaux, which is Authorities for tab 26, starts at MS 1335. And the passage that my Lord Mance pointed to, which I was going to come to next, paragraph 82, MS 1370. There's reference to the opinion of the European Group on Ethics at Community Level about when lack of consensus about when life begins. And then after the quotation, the court says, it follows that the issue of when the right to life begins comes within the margin of appreciation the court generally considers that states should enjoy in this sphere, notwithstanding an evolutive interpretation of the convention, a living instrument which must be interpreted in the light of present-day conditions. The reasons for that conclusion are, first, that the issue of such protection has not been resolved within the majority of the contracting states themselves, in France in particular, where it's the subject of debate, and secondly, that there is no European consensus on the scientific and legal definition of the beginning of life. And the respondents place enormous weight on that passage. But it's worth being clear, in fact, it's really important to be clear, that isn't the issue in this case. The issue in this case is whether the women in our categories have a right to an abortion because of the imposition on their personal autonomy. And in contrast to the issue that arose in Vaux about when does life begin, if you look at the two reasons that the Strasbourg court gave for recording that margin of appreciation in Vaux, those two reasons point very strongly in our favour in the issue in this case. First, the issue of such protection has not been resolved within the majority of the contracting states. The issue of whether women and girls can have abortions in case of rape, incest and serious fetal abnormality has been resolved within the majority of contracting states. There is a consensus. I don't think there's any issue or dispute about that. Secondly, no European consensus on the scientific and legal definition of the beginning of life. That, I'm sure, is right and remains right. But there is a European consensus, both in state law and in international law, as to the entitlement of women in our situations to abortion. So it's very important not to muddle what was in issue in Vaux with what is in issue in this court. And then the next point, which I just presaged briefly before lunch, is that the issue of protection of the fetus in domestic law has been decided in UK law extremely clearly and for a long time. So there are many cases, as the family lawyers here will know, but the one we've picked is Re MB, which is volume 10 of the Authorities, tab 90, MS 3433. And this was, of course, one of the emergency caesarean cases. Judgment of the Court of Appeal in England. And if the court goes to, first of all, 3445 under the heading of the unborn child, top of page 440, the court, yes, it was Lady Justice Butler Sloss. In our judgment, the court does not have the jurisdiction to take the interest of the fetus into account in a case such as the present appeal, and the judicial exercise of balancing those interests does not arise. And then they go on to cite a line of cases, including...
Where was that on 3?
I'm sorry, page 440 of the judgment, 3446
Yep.
of the MS, top of the page.
I
first
see it, thank you.
Yep.
I suppose we should explain that this is a case about whether a woman can be forced to have a caesarean in order to save the life of her unborn child.
Yes, I'm sorry, my lady, I shortcutted by said forced caesarean. Yes, absolutely. So the issue was, I think the facts of this one, well, you can see at 3432, she... I think it's right. This is another of those cases where the poor High Court judge, very understandably, ordered in a highly emergency situation that the consultant gynaecologist could operate to provide a caesarean. And then in the fullness of time, it came back to the Court of Appeal, and the issue was as to whether or not the judge was correct to reach that conclusion. And passage 440 onwards, Her Ladyship goes through the very long-standing and consistent case law which says that the fetus does not have autonomous rights in that situation. I'm not going to read through all that. One of the leading...
I mean, is this necessarily Northern Ireland law?
My Lord, I was going to come to the point. First of all, there's a House of Lords judgment to the same effect, albeit in a criminal context. And secondly, there is not a single case that suggests that Northern Irish law is any different.
Yes, I mean, it appears that Irish law is different, just looking at the Irish Constitution at the moment.
Irish law, the Republic of Irish law is undoubtedly different, no question about that. It's not the issue here. This is the long line of Court of Appeal and High Court judgments in England to precisely the same effect. No suggestion that Northern Irish law is different in this regard. No case that suggests any different test. And given that it's highly likely, I mean, one can't say it's necessarily the case, but I suspect any family lawyer will know that it's highly likely that the issue of whether or not a woman can be forced to have a caesarean, if to have the caesarean would save the life of the child, of the baby, and not harm the mother, is likely to have arisen at some point in the last 30 or 40 years in Northern Ireland. No case that suggests the law is different.
What is to be inferred? I mean, Northern Ireland doesn't have a written constitution in the same sense as Ireland, but could one start to draw inferences from the refusal of the legislature to change the Northern Irish law that, in fact, there's a different view about the unborn fetus?
My Lord, you cannot draw the conclusion that the rights of the fetus, as explained in this case, MB, are any different. What is clear, and it's really important the court understands this distinction, what is clear is that Northern Irish abortion law is more restrictive. So the statutory protection of the fetus is different to the rest of the United Kingdom. That's why we're here. But that doesn't mean that in Article 2 terms, or the margin of appreciation terms, the fetus has any different rights other than the very statutory provisions which are at the heart of this case. And I'm going to obviously come to the issues of what are the moral views of the Northern Irish people and institutional competence later. But what we have here is a very clear line of authority that says the fetus in United Kingdom law, other than statutory protection, and we'll come to that in a moment, has no autonomous rights. So 441, at the end of this section, none of the above decisions lends any support to the proposition that the court should take into account the interests of the unborn child at risk from the refusal of a competent mother to consent to medical intervention. Then over the page, importantly, the court deal with the European Commission of Human Rights and Article 2. Reference is made to Article 2 there. They go through what was then the Article 2 case law, including that Commission decision H in Norway, which is cited in Vaux. Then they discuss the American authorities. And then at 444, Lady Justice Butler-Sloss, in the middle of the paragraph under our conclusions on the interest of the unborn child, says, the fetus up to the moment of birth does not have any separate interests capable of being taken into account when a court has to consider an application for a declaration in respect of a caesarean section operation. The court does not have the jurisdiction to declare that such medical intervention is lawful to protect the interest of the unborn child, even at the point of birth. So that is the status of the fetus in that line of cases. And the House of Lords authority, which doesn't actually cast any further light on this and only deals with the issue quite briefly, is AG reference 3 of 94, authority bundle 6, tab 47, MS 1941, where the issue in that case is whether an attack on a pregnant woman, which led... She then gave birth to a grossly premature child who only survived for 121 days. And if I ask the court to go to 254 in the speech of Lord Mustill, which is MS 1950, where, top of the page, these are the established rules that he goes through. Except under statute, and that's the critical point, an embryo or fetus in utero cannot be the victim of a crime of violence. In particular, violence to the fetus which causes its death in utero is not murder. And then you can see at page 256 consideration of the fetus as a separate organism. So it's true to say that all of those cases refer to are English cases, but as I've said, there is no case, and I'm sure extensive research has been undertaken, that suggests that the law on fetal rights is any different in Northern Ireland. So can I then return to Article 8 itself?
Well, this is a case about the law of murder, wasn't it?
It was.
Presumably the law of murder is the same in Northern Ireland. Then.
Well, indeed, my lord, my lady, my understanding is that it's a House of Lords decision on the law of murder. So it's setting out, jurisprudentially, it's setting out the law in Northern Ireland as well as the law in England. Your ladyship's entirely right. But it is right to say that it's a case that the factual issue arose in England. So, coming back to Article 8 and the balancing exercise, can I ask the court to take up ABC, please, which is volume 3, tab 13, MS 814. And this is the case that the respondents place almost total reliance on, and indeed argued at the leave stage we shouldn't even get permission on Article 8 because of this case. So it's important to understand what the case was about and how the Strasbourg court reached its conclusion. So the section of the court's consideration on Article 8 starts at MS 871, paragraph 212. And as I said this morning, just remind the court, this case did not concern victims of rape, incest, or women with serious fetal abnormalities. From 222, the court addresses the question, did the interference pursue a legitimate aim? And this court, your ladyships and your lordships, will have to, I'm afraid, read with some care 222 through to 242. In my submission, and I'll show the court the passages in a moment, the fundamental issue which led to the finding of no breach on Article 8 was the findings as to the profound moral views of the Irish people as to the nature of life. So we'll come back to 222, but if the court could just flick forward to 241, which is the final conclusion. There's a lot of angsting in this case as they sway in different directions. 241 is the final conclusion. Accordingly, having regard to the right to lawfully travel abroad for an abortion with access to appropriate information and medical care in Ireland, the court does not consider that the prohibition in Ireland of abortion for health and well-being reasons, based as it is on the profound moral views of the Irish people as to the nature of life and as to the consequent protection to be accorded to the right of the life of the unborn, exceeds the margin of appreciation accorded in that respect to the Irish state. Therefore, they find fair balance. So absolutely at the heart of this decision, both at the stage of legitimate aim and at the stage of necessary in a democratic society, is the evidence on profound moral views. 222, the court recalls that in the open door case it found the protection afforded under the Irish law to the right of the unborn, life to the unborn, was based on profound moral values concerning the nature of life, which were reflected in the stance of the majority of the Irish people against abortion during the 1983 referendum. And they refer again in 223 to the 1983 referendum. The evidence, so that was the evidence before the court in ABC. The evidence in the present case as to the views of the Northern Irish population is starkly different. The best and most recent evidence of the views of the Northern Irish population is set out in the Northern Irish Life and Times Survey 2016. So what I'm going to do is work backwards and show you the most recent evidence and then the evidence before that. The 2016 survey was not before the Court of Appeal or the High Court because it hadn't been carried out at that stage. And before we look at it, I just want to emphasise this isn't an opinion poll carried out by a newspaper. It's a survey conducted by the two Northern Irish universities, Queen's University and Ulster University. Now, you'll find that evidence in Core Volume 5, towards the back, in the material produced by the 7th intervener, at MS 10930.
Sorry, page again?
You'll have to use the MS numbers, I'm afraid. 10930. Attitudes to abortion in Northern Ireland, and it starts by saying, in 2016, the Northern Ireland Life and Times Survey asked the Northern Ireland public their views on a range of issues relating to abortion and abortion law. This is the most comprehensive survey of public attitudes on abortion to date. This research paper presents key findings from the survey. And if I can take you first to Table 1 on the first page. And this breaks down the views, as you can see on the left-hand side, onto fatal fetal abnormality, serious fetal abnormality, rape or incest. We only need to worry about the first three horizontal lines. And then the first two columns definitely should be legal, probably should be legal. So to give the court the headlines, for fatal fetal abnormality, 81% of the people surveyed thought that that should be legal. either definitely or probably. For serious fetal abnormality, the equivalent figure was 73%, and for rape and incest, the equivalent figure was 78%. The numbers on the other side, i.e. excluding the don't knows, were fatal fetal abnormality 16%, serious fetal abnormality 23%, rape and incest 19%. Just to give the authority, as it were, of that survey, if I can ask you to turn to 10937, you can see at the bottom that this was carried out by Anne-Marie Gray, who's a professor of social policy at Ulster University. It was funded by the ESRC, the Economic and Social Research Council, and it was in collaboration with Queen's University and Ulster University.
And 1,208 adults took part, and presumably somewhere there's an account of the methodology.
I'm sure there is, my lady, and we can certainly get it for the court if the court wants to see it. In my submission, the court can place considerable reliance on the academic credentials of both its funding and the people who carry it out. Yes, and your ladyship took the words out of my mouth, 1,208 adults. In my submission, that is the best evidence of what are the profound moral views of the Northern Irish population. It is relevant that that evidence is not actually very different from the evidence produced by Miss Simpson of the FPA at the start of these proceedings. So if the court could take up CV2, Core Volume 2, 505, MS 9280, page 505 for those in the hard copies. This is the witness statement of Miss Simpson, who was the director of the Family Planning Association at that time. In paragraph 10, page 9280, MS 9280, she summarises the findings carried out by a polling organisation called Millward Brown for Amnesty International in September 2014. And what she says there is 69% of people think the law in Northern Ireland should make access to abortion available where the pregnancy is a result of rape, 68% where it's the result of incest, 60% where there's a fatal abnormality. So the support for the principles in our case seems to have got stronger, but what that shows is that the NILT survey is not by any means out of step with other material. So the first point is the evidence on the views of the Northern Irish population is very different from the evidence before the Strasbourg court in ABC. Now, in ABC, Strasbourg obviously relied on the 1983 referendum, and Northern Ireland has no process of referendums for anything other than major constitutional issues. And Lord Justice Weatherup in the Court of Appeal, we don't need to see it, but I'll give you the reference, at paragraph 145, MS 8820, rejected Miss Simpson's evidence and said it was a little weight because it was opinion polls. But 2 points on that. First of all, the NILT survey is, in my submission, the best evidence of the views of the Northern Irish population. It's up to date, it's academically verified, and it's absolutely clear. And the second point is that actually we gain support for our reliance on that from what the court said in ABC. Because in ABC, at paragraph 226, the court did refer to the survey material there. But what they said, MS 874, was in light of the above, and that is the referendum and the processes that have been undertaken in the Republic, In the light of the above, the court does not consider that the limited opinion polls on which the first and second applicants relied are sufficiently indicative of a change in the views of the Irish people concerning the grounds for lawful abortion in Ireland as to displace the state's opinion to the court on the exact content of the requirements of morals in Ireland. And that's important because the Strasbourg court was not saying don't have reliance on opinion polls. The Strasbourg court was saying that the evidence from those opinion polls was insufficient. So the suggestion, Lord Justice Weatherup, that reliance shouldn't be placed on opinion polls doesn't actually accord with Strasbourg's position. So the starting point on ABC is that the respondent's case on legitimate aim is not supported by the evidence and not supported by ABC.
When the court says in paragraph 226 that the opinion polls aren't sufficient to displace the state's opinion to the court, is that the opinion founded on the results of the referendum? Or?
Indeed, my lord, that's how I read it, yes.
Curious way of putting it.
Yes. Because that takes you back to 226, because the starting point was the referendum, and then you can see in 223 the argument of the applicants was that the position had changed since the referendum.
Yeah.
And then there was an issue, and I'm afraid, my lord, I haven't got to the bottom of this. I'll do so for reply. That there had been,
don't waste time on it.
there'd been some further consideration of whether to have a further referendum in the Republic. That's the reference to the Lisbon Treaty. But I'll
don't worry,
get to the bottom of that.
About that now.
So that's, did the interference pursue a legitimate aim, and why ABC is completely different. Next heading, 229, was the interference necessary in a democratic society? And this is where the court at 232 grapples with the issue of margin of appreciation. And just worth reading 232.
Well, on 230 perhaps is also perhaps interesting in seeing what the balance was regarded as being between, what the competing interests were.
Yes. Yes. Yes, I'm sorry. All these passages are incredibly important. I'm just quite short on time, so I'm bouncing through. But absolutely, all of this is completely relevant. 232, they consider the issue of margin appreciation. Third line, where a particularly important facet of an individual's existence or identity is at stake, the margin allowed to the state will normally be restricted. So that very strongly points in favour of restricted margin. Where, however, no consensus within the member state of the Council of Europe, either as to relative importance of the interest at stake or the best means, particularly where the case raises sensitive moral ethics, the margin will be wider. Again, in my submission, that points very strongly to a narrow margin. And interestingly, the Strasbourg court goes on to say that there was a consensus here, even in ABC, but in my submission, the consensus is even stronger in this case. Consensuses are not an absolute, they're on a spectrum. There was a consensus in ABC, but here there is an absolute consensus on our three situations.
I personally find the reasoning perhaps raises this question. If the profound moral views of a people on a particular point are relevant at all, why should it matter whether there is consensus on them in other member states? Why should their acceptability depend upon a majoritarian appreciation? I mean, if you can say that the moral views are in fact immoral or wrong, then that's one thing. But if they are tenable moral views which may have a religious base which can't be controverted, why don't they stand by themselves, independent of whatever other people happen to think?
Well, my Lord, two answers to that. One is there is a very strong argument, and I would ask you to read Miss Rose and Mr Bunting's intervention on this, that the court in ABC muddled, to put it kindly, the relevance of moral views as against consensus. The normal approach on margin of appreciation is where the Council of Europe states have a clear consensus, then that will guide the outcome of the Article 8.2 breach, Article 8.2 balance. It cannot be the case that human rights can be taken away because of the moral views of the population. That would be contrary to the fundamental...
Slightly circular point, isn't it? I mean, does one have a human right to override a sincerely held religious belief?
Absolutely, Mike.
We do.
Well, absolutely.
So, effectively, I mean, the court at one point in its judgment would appear to me to be saying that there are some moral views which are worthy of intrinsic respect, and we will accept them irrespective of what the consensus says elsewhere. You say that's a completely wrong approach.
My Lord, it would be inhuman not to understand the dilemma that this court had in the Grand Chamber and what they were trying to balance. And if you read these paragraphs, it's clear that they are balancing one way and another, taking into account different factors and desperately trying to be seen to be according all of those. To some degree, your lordships and your ladyships don't need to worry too much because the facts of our case are so much clearer because it is the three categories. But if you do feel, and I completely respect the court for feeling this, to try to analyse out what the reasoning in ABC is, it's yes, you can take into account moral views, but only up to a point. When you have the situation, in many ways, the court doesn't need to worry about it because the moral views of the Northern Irish population are completely different. The evidence is so clear. What the moral views against my case are, to put it frankly, those of a small proportion of the Northern Irish population. But if, to the degree one wants to try to understand and grapple with the reasoning in the Grand Chamber, it's yes, moral views are relevant, they're not determinative, and we're going to put them into that balance against other factors. That's the only way I can find to read these paragraphs. But it is
there is a bit of a similarity between this case and the Lautsi and Italy case, isn't there? In the Grand Chamber.
I would love to say yes, my lady, but I'm afraid the facts of Lautsi have completely escaped me.
Oh, that's the crucifixes in Italian state school.
Oh, yes, yes.
And the similarity is that you have something that is very long and deeply established in the particular national psyche and situation, which, in the end, the Grand Chamber attempts to accommodate.
Yes.
Unlike the Chamber decision in Lautsi. So there is a similarity there, almost also with the French case about face veils.
Yes. But also, my lady, and in answer to Lord Mance's questions, one can go back to the case of Dudgeon. So there are profound moral views, and certainly were at that stage in Northern Ireland, about the legality of homosexuality. And yet in that case, Strasbourg had little difficulty in finding that there was a breach certainly of Article 8 in the criminalisation of homosexual activity.
My lady's unquestionably right that there are similarities with Lautsi, but I assume you would want to make the point that the weight to be given to profound moral views as they affect the individual who holds them may be greater, or must be greater, than profound moral views which you seek to impose on others.
Absolutely, my lord. But also, perhaps the most important distinction from Lautsi is the impact of those moral views on the other person. Article 8 is where one can almost see the balancing going on. It's one thing to take quite a lot of credence of moral views about people wearing crucifixes. It's a completely different thing to give significant weight to the moral views of a certain number of people that imposes the greatest possible intrusion into a woman's personal physical autonomy. You're just not talking about the same thing at all. It's a bit like my learned friends relying on countryside alliance.
My Lord's question and your answer it doesn't entirely solve the problem, because they assume what they have to prove, namely that you can ignore the interests of the fetus. And if the moral view is that the fetus is equivalent to a person, then it's not just a two-party situation, it's a three-party.
Yes, and I'm just about to come to the fetus. So that's evidence on moral views and margin of appreciation. Next, what is the interest or purpose which is said to justify this extreme intrusion into women's personal autonomy? So it's said by my learned friends to be the protection of the fetus. But this is the point where one just has to face the reality. These laws are not protecting the fetus. The abortions are taking place. They're just either taking place unlawfully and criminalising women for no purpose, or they're forcing women to travel. So what's really happening in Northern Ireland?
Can I just ask about that? I mean, there is, I think, a written submission to the contrary, and I'm not quite sure how we deal with that. There's a written submission to the effect that, in fact, these laws are saving, as they put it, or at least ensuring that 100,000 extra children have been born. Now, you can, how do we deal with that?
Well, my lords, my ladies, I would treat that 100,000 with massive scepticism. There's a number of points to be made. First of all, it's 100,000 ever since the 1967 Act. That's how the calculation's done. I have no idea, and there is no evidence, as to how many women back in the 70s and 80s and 90s may have continued with pregnancies because they had no choice. The situation now is that, first of all, early medical abortion tablets are available over the internet and easily available. And secondly, that thanks perhaps to Mr. O'Leary, getting to England is a great deal easier than it would have been in the 70s and 80s. It is there is no evidence that at the present time women are and girls are continuing with unwanted pregnancies, save in a minute number of cases. Obviously, Ashley Topley is an example, but of course I'll come in a moment to the life saved there. But there is, I'm sure, despite every effort, not just by the respondents but by the interveners, to find evidence of lives, as they would put it, saved. There's no evidence of that. I can't say, of course I can't say it never happens, but it's going to be a tiny number. What the evidence does point to is abortions taking place. There are statistics in the consultation document of the number of women coming to England, Northern Irish women coming to England. I expect the court remembers it from A and B, something in the region of 1,000. The interveners certainly suggest that that's an underestimate because many women who've come to England for abortions don't give their Northern Irish addresses. The statistics, and I'll ask Mr. Blundell to find them while I'm speaking, what the statistics show is that the number of abortions taking place in England by Northern Irish women seems to be dropping. Now, whether that's because sex education in Northern Ireland has got better, or whether it's also because early medical abortion pills are being taken in a number of cases, one just doesn't know. Self-evidently, you can't ask people if they've committed criminal offences and hope to get a true answer. But I would ask the court to find at the highest that there may be a very, very small number of women who are proceeding with pregnancies.
Well, in the categories you're talking about.
In the categories I'm talking about, my Lord. Yes,
It's
absolutely.
quite important that we keep that in our minds
Absolutely.
throughout. Because, of course, the great concern is for the much freer availability on much wider grounds.
Yeah. Although, my lady, even on the total number saved, and of course your ladyship's entirely right, and I should have started with that, the 100,000
What
is
about the
everybody.
total?
Yes.
That figure is about the total
Total,
number saved.
yes. But even in terms of women generally, there's no evidence of any material number of babies being born where the woman had wanted an abortion. Maybe happening, but I can't say it never happens.
Thank you.
So certainly, as my lady absolutely rightly points out, in this category, the fetuses are not being saved. The other side of the balance is a postage stamp. There isn't anything there. And then, in the case of fatal fetal abnormality, the position is even starker, because there is either no life after birth, or that life will last for a matter of days. Maybe it'll be days, maybe it'll stretch to 10 days or 2 weeks, but it will be very short. Now, of course, if you do have the profound moral view that from the moment of conception the life is equal to my life or your ladyship's life, then fine. The fact that the fetus will die anyway is irrelevant. But in my submission for this court, when putting something into the balance, the fact that in the fatal fetal abnormality cases there is going to be no life beyond a few days is highly relevant. So bringing together the balance, we looking at what was considered in ABC, we have a completely different position. First of all, we have a completely different category: rape, incest, serious fetal abnormality. Not dealt with by ABC at all because it wasn't the issues. Secondly, we have completely different evidence on profound moral views. Thirdly, we have different impacts in terms of the need to travel and the impact of travelling. And fourthly, the ABC didn't really grapple with the issue, as far as I could see, that the majority of, or many of, those fetuses would be aborted in the end in any event. And in my submission, that point brings one to the question, what is being protected here isn't, save in a tiny number of cases, the life of the unborn. What it does seem to be is the moral purity of a small part of the Northern Irish population by being able to say those abortions aren't taking place in Northern Ireland. They may be taking place somewhere else, but my moral purity, my moral views are protected by, as Mr. Justice Horner put it, exporting the problem.
Oh, so and there is a counter-argument. I might say, why bother having laws against child sex abuse in the UK if the reality is that people who want and can afford to go to the Far East in order to indulge their habits? If in Northern Ireland the administration is correct in saying that there's a great moral importance attached to protecting the life of a fetus, unless they're going to restrict the movement of all pregnant women, they can't, in practical terms, prevent people from leaving Northern Ireland to have abortions elsewhere if that's what they want to do. But they can say, we're going to give effect to the moral beliefs of Northern Irish people within our jurisdiction.
But 2 points on that, my lord. First of all, in terms of sex abuse, you are protecting the children in the United Kingdom. You are actually, in international law, protecting other children as well, and actually there are many international offences in that regard. But the law has a purpose. It's the protection of children within the jurisdiction, and those children are being protected. There may be other children who aren't being protected, but the law has a real purpose. But secondly, in terms of you can't stop people travelling, come back to Article 8 and the balance. If you know, it's not like sex abuse, because the sexual abuser in Ireland may or may not travel to Thailand, may abuse children in both. The woman who's pregnant in our three categories, who travels to England, is having the abortion. So you're not protecting the fetus at all. You may not be able to protect the fetus, but that helps me, my lord. If your lordship's right, and analytically the way to look at this is actually it's impossible in a globalised world with cheap travel and we ignore the EMA tablets for this purpose, globalised world with cheap travel, you can't stop people having abortions, then why punish them by forcing them to travel? What is the justification? I understand the counter-argument, but it comes back to this weight issue. How much weight can you give to the desire to protect 18% of the Irish population, Northern Irish population's morality, by not protecting the fetus, you're just protecting their moral views. And that's why it's important to distinguish between the protection of the fetus, which is not being achieved, so can't go in the balance, and the protection of the morality of that small minority of the Irish population, which, how much weight do you give that to? How much weight do you give the fact that I may be morally opposed to something and I'm going to be allowed to place that moral position on somebody else's personal physical autonomy? I'm not saying it's, to put it in the words of planning law, which is always my last resort, I'm not saying it's not a material consideration, but I am saying it's one you'd give very little weight to.
So essentially the point you're making is that you give less weight to the moral value attached to protecting the life of the unborn if in reality, to the extent that in reality protection is not realistically achievable.
Yeah. Because you are causing severe hardship to women and girls for something that can't be achieved. So the next issue, still under the heading of Article 8, is institutional competence. So this arises because if the court is with me on Article 8, that there's a breach of convention rights, the issue that then arises is should it make a declaration of incompatibility, or should it leave it? Should the court leave the matter to somebody, not entirely clear in Northern Irish constitutional position who, but somebody to consider the matter further. Now, in terms of what happens next, in terms of remedial orders and so on, that is not a matter for today. But institutional competence was plainly an issue for this court in Nicklinson, and also in the earlier case of Ree. First point to make about Nicklinson is what is quite plain is the fact that the case, Nicklinson and Ree, the fact that the case raises issues of morality doesn't and shouldn't stop the court from making a ruling. So it's not a no-go area. Now, Nicklinson is at volume 2, tab 7. And I'm very conscious of the fact that I think 4 members of the court in Nicklinson are in this case. And also that it's a long and complex judgment with a number of slightly different points being made in respect of institutional competence. So rather than doing a major textual analysis at this stage, it's MS 380.
Well, was my summary accurate?
According to Mr. Blundell, your summary was accurate, my lady. So I just want to make 4 points on Nicklinson, and then 4 points on why this case is different. So the first thing to say about Nicklinson is there was no consensus at the European level on the right to die issue, either in terms of practice in the European state, the Council of Europe states, or in terms of international law. No consensus. Secondly, the court had before it the case of Pretty in the UK that was close to directly on point. Thirdly, and in my submission, it's always very difficult to make submissions as to what was critical to the court's thinking when I have four members of the court in front of me. But thirdly, and as I read Nicklinson critically to many of the judges' thinking, Parliament was about to debate the very issue in Lord Falconer's bill. And I say that was critical to some of your lordships and your ladyships' thinking. If I just give you the reference, so Lord Mance at paragraph 190, Lord Wilson at paragraph 196, referring back to paragraph 115 in Lord Newburger's speech, and I think my Lord Reid as well, although I haven't got the paragraph number. And fourthly, there was a very particular issue as I read Nicklinson and then as I read the subsequent case of Conway, which is Divisional Court just given judgment on. There were very major issues in Nicklinson about the safeguards for the very people who were seeking to rely on Article 3. So there was a very clear conflict within the class, in terms of, not in terms of the argument being presented, but a fundamental issue in the whole right to die debate was, would it impact wrongly, deleteriously, on the very vulnerable people who were in issue? Contrast that with the present case. There is consensus. Secondly, Strasbourg has not given any decision on the point. Thirdly, it is entirely clear, and I may need to come back to this in reply, that the Northern Irish political process will not, in the foreseeable future, vindicate these girls' and women's rights. I'm sure the court has read the case, particularly Dr. McGlennan's case, about the process that's been undertaken in Northern Ireland and the fact that that process is now going no further. Quite apart from the fact that the point that Dr. McGlennan slightly passes over, which is that there hasn't been a Northern Irish Assembly since, I think, February of this year. So it's a completely different position to that in Nicklinson in respect of Lord Falconer's bill. And fourthly, unlike Nicklinson, there is here the most flagrant breach of international law. In my submission, the more helpful case, or the more analogous case, is that of Re G. And if I can ask the court to take that up, that's volume 1 of the authorities, tab 2. And Re G, I think Baroness Hale and Lord Mance were in it, but for the other members of the court, Re G is the case about adoption by unmarried couples in Northern Ireland. And there are two important issues that come out of Re G. One is, should the matter just be left for the political process? And secondly...
It's in bundle 1.
I'm sorry.
2.
No, I'm just...
Volume 1, tab 2, MS 101.
Thank you.
So should the matter just be left for the political process? And secondly, the respondents argue strongly that this court shouldn't go further than Strasbourg and rely on what I would call the Ulla principle, Strasbourg and no further. And Re G deals with that issue in terms. I have to say, the simple answer to the Ulla argument is that there is no Strasbourg case that you would be going further than or differing from. But in any event, If one looks at the analysis in Re G, first of all, in the speech of Lord Hoffman, at paragraphs 36 to 37, Lord Hoffman considers the issue of where Strasbourg says something is within the margin of appreciation. What should the UK courts do? What's the role of the UK courts? And he refers, going back to 30, and he refers to the well-known passage of Lord Bingham in Uller. And then he refers at 35, midway through, if Strasbourg has decided that the International Convention confers a right, it would be unusual for a UK court to come to the conclusion that the domestic convention rights did not. But then the critical passage is 36. Other reasons for following Strasbourg are ordinary respect for the decision of a foreign court on the same point and the general desirability of a uniform interpretation of the convention in all member states. But none of these considerations can apply in a case in which Strasbourg has deliberately declined to lay down an interpretation for all member states, as it does when it says that the question is within the margin of appreciation. In such a case, it's for the court in the UK to interpret Articles 8 and 14 and to apply the division between the decision-making power of courts and Parliament in the way which appears appropriate for the UK. The margin of appreciation is there for division between the three branches of government, according to our principles of separation of powers. There is no principle by which it is automatically appropriated by the legislative branch. And then Baroness Hale at paragraph 120.
Well, I suppose it's worth pointing out what the result was in the case.
Indeed, that the court...
The majority of the House of Lords decided that the Northern Ireland law was incompatible by UK standards,
Yes.
and so declared it.
Absolutely. 120, MS 143. Hence, if there is a clear and consistent line of Strasbourg jurisprudence, our court will follow it. But if the matter is within the margin of appreciation which Strasbourg would allow to us, then we have to form our own judgment. And 128, in the speech of Lord Mance, MS 145, at the domestic level, nothing in the Convention precludes contracting states from introducing in their constitutions or general laws more extensive protection. UK doesn't have a written constitution, but it does have the Human Rights Act. And then over the page, meaning of the new domestic rights scheduled to the 98 Act is a matter of domestic law, through though UK courts must take into account any Strasbourg case law, but a Strasbourg decision that a matter falls within the contracting state's margin of appreciation leaves issue B to the national authorities of contracting states. Contrary to Strasbourg's court's purpose and circular, if national authorities take the view that they shouldn't consider any question other than whether a particular solution was within the UK's margin of appreciation. And then 130, your lordship refers to Kay and Lambert, and then about part way down, 2/3 of the way down, in performing their duties under sections 3 and 6, courts must of course give appropriate weight to considerations of relative institutional competence, that is, to the decisions of a representative legislature and a democratic government within the discretionary area of judgment accorded to those bodies, though the precise weight will depend on inter alia, the nature of the right, and whether it falls within an area in which the legislature, executive or judiciary can claim particular expertise. Now, applying those words, in my submission, it's perfectly understandable why the court would find in the context of right to die and the issues there, that certainly at the date of Nicklinson, that felt most appropriately within the expertise of Parliament. But here, there are two factors. One is that, as I've already said, the Northern Irish constitutional process has, as it were, run its course. And secondly, in terms of the impact on the women and girls in question, this court is in just as good, if not better, position to judge that impact than...
Ms. Leaven, I'm afraid I've forgotten what the ultimate result was in Northern Ireland of the declaration of incompatibility in Re G. What happened to the adoption rules?
The law was changed.
Yes, I've got a paper on it. So, Lord Kerr, can I look to you for the answer?
Well, I thought I'd given it.
It's the automatic effect of our decision. That part of the, because it was delegated legislation.
Secondary legislation.
Oh, secondary legislation.
Yeah. So it wasn't a declaration of incompatibility
It wasn't.
in the Section 4
Right.
sentence.
Thank you very much for clarifying that.
It was the Northern Ireland Adoption Order.
Yes.
So our saying that the restriction to married couples was incompatible meant that it couldn't be restricted to married couples.
Thank you.
And
I got in my head that there was some case which the appellate committee decided, and the Northern Irish legislature government was very, very slow to react to it.
Well, I think they may have been quite slow to change their actual practice.
I don't think we didn't strike down the legislation, though, did we? All we did was make a declaration that these applicants were entitled to apply to adopt the child. And that was on the basis that, if ever it was clear that any unmarried couple was entitled to be considered for adoption, it was this unmarried couple because they'd been living together in a stable relationship for 10 years.
With the child.
With the child, exactly.
For a long time.
And so we weren't saying that
It weren't saying that every unmarried couple could adopt,
no.
but it was
No.
the exclusion.
It's a bit like the voting situation.
it's a bit like the voting case,
Yes.
I was going to say. As I understand it, the ratio of the court's judgment was that you couldn't have a blanket rule.
And therefore, presumably, something has been substituted, has it, by way of a new rule which does draw a different
Yes.
line.
Well, I don't know what the answer to that is, but theoretically, I suppose, once it is declared that that blanket exclusion can no longer apply, I suppose it is technically possible to leave it on the statute book but not to apply it. But I should be surprised if there wasn't some amendment. But Mr. McLean will reveal all in due course.
Yes, hopefully Dr. McLean will reveal all, and if he doesn't, I'll check overnight. I'm being told that there was a subsequent case, and that may cast light on it. But
There was a subsequent case where, in effect, that effect was clarified, and there was an application for permission to appeal to this court. I think the attorney may recall that, but and it was refused on the basis that the position was perfectly clear. I'm getting nods from behind you, Miss Lee.
yes, the thing is, my lady, I don't want to say something on the basis of a quick conversation and get it wrong.
No.
I'd rather go away and work out exactly what the situation is.
Yeah.
Because
I think that was-
I
I think
don't
that was what it
know,
was.
and I'm...
Very well, thank you.
The other point I just want to flag on institutional competence is a point made by Lord Neuberger in Nicklinson, which may have some resonance here. It's paragraph 104 in Nicklinson at MS 513, where his lordship, there was reference to Countryside Alliance, and as I've already said through rather gritted teeth, that was a very different case where the impact on somebody's Article 8 rights were of a quite different order. And Lord Neuberger then says, quite apart from this, there is force in the point that difficult or unpopular decisions which need to be taken are on some occasions more easily grasped by judges than by the legislature. Although judges are not directly accountable to the electorate, there are occasions when their relative freedom from pressures of the moment enables them to take a more detached view. As Lord Brown said in Countryside Alliance, sometimes the majority misuses its powers, not least that this may occur when what are perceived as moral issues are involved. However, save as some have argued in circumstances which are very unlikely ever to arise, parliamentary sovereignty and democratic accountability require that the legislature has the final say, as Section 4 recognises. So ultimately, the constitutional settlement is that the matter has to be for the legislature. But that should not, and indeed it would be wrong in principle for that to stop this court making the declaration sought. So, can I then pick up 2 points under the heading of Article 8, which don't fall happily anywhere else? The first is the definition of serious fetal abnormality and the argument placed by the respondents that if the declaration of incompatibility is given, then the test is impossible to apply. And that is an argument against making any such declaration. 2 points that I'd just like to make at this stage. First of all, it is indeed the case that the precise parameters of serious fetal abnormality would need to be established. And in the first instance, that would be a matter for the state authority. And that could be done in a number of different ways. It could be done by primary legislation, by secondary legislation, and or by guidance. And as we've seen from the Council of Europe evidence, there are slightly different definitions that could be given and slightly different ways of approaching the issue. But second, ultimately, what is a serious fetal abnormality has to be a clinical judgment in exactly the same way that the test under the 1967 Act, which I won't be able to put my hand on right now, but one part of the test refers to, I think it's serious handicap. And plainly, what that means will ultimately be a question of clinical judgment. I'll just find the 67 Act, because it's probably worth... Yeah, so volume 4, tab 28. Yes, section 1, MS 1411.
Sorry, MS
1411, tab 28. So, limb D of the grounds for abortion, that there's a substantial risk that if the child was born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. So, plainly, that is ultimately a clinical judgment. And equally, of course, the judgment underborn is a clinical judgment. So the idea that you can't have serious fetal abnormality because it's impossible to define is, in my submission, completely wrong. And then the other thing I just wanted to deal with here, because it fell as well here as anywhere else, is the respondents' reliance on the United Nations Convention on the Rights of People with Disabilities. And we deal with this fairly comprehensively in the reply. But if I can just give the court the headline points in this respect, and there are 4 points to be made. The first is what the respondents systematically fail to acknowledge is that it has no relevance to the case on rape and incest. The position of the UN CRPD committee simply doesn't touch on those issues. Secondly, and again, perhaps even more fundamentally, a point that the attorney certainly never addresses, is that the UN CRPD committee, the observations he relies on, show that the committee is not opposed to abortion. It has no problem with, for example, a 12-week limit in any state's abortion legislation. The committee's problem is with differential gestational limits. So the committee's problem is with the provision in, for example, the 67 Act that allows abortions much later on the grounds of serious handicap. So the UNCRPD committee would not object and would have no grounds to object to a general right to abortion at 12 weeks. What their problem is differential limits. The third point, there is a slight irony in the strong reliance the attorney places on a committee which is actually completely contrary to his case. The third point is that the committee's views are out of step with all the other international bodies, which we've seen, who support abortion on the grounds of serious or fetal abnormality. And there is no European or international adjudicative body that has found a right to life pre-birth.
Can you just tell me where you see the committee views?
Sorry, where the convention is.
Well, where you say the committee, which you've just been discussing.
Oh, so what my lord has to do, I'm sorry, I'm taking this very shortly, is go to it's dealt with in both the department's case and the attorney's case, but it's dealt with in much more detail in the attorney's case, which is at MS 8663, and I'll just find, and it's page 8708, page 46. And the attorney has a long passage on this, starting at paragraph 90 and going through to 100. And he relies on, at paragraph 91, Article 10 of the UNCRPD. State parties reaffirm that every human being has the inherent right to life, to take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others. And he says that the use of human being instead of person is relevant. And then over the page at 94, he refers to the views expressed by the UNCRPD committee. And the point I was just making, my lord, in respect of paragraph 94 onwards, is that the views of that committee are out of step with all the other international bodies. But also, if the views of that committee were right, then I can't do the maths, but if one goes back to Mr. Allenby's annex, a very large proportion of the Council of Europe states would be in breach of this convention. Because although one can't say that it's uniformly the case, out of the 40 of the 47 that there's provision for fetal abnormality, it is the case in the vast majority.
Can I ask, is there a distinction to be drawn under this convention between the fetus which has a fatal abnormality and the one which doesn't have a fatal abnormality but may be born disabled in some way?
My lord, not on the attorney's interpretation. The attorney certainly advances the argument that this applies equally to a fetus that would die the day after birth as to a fetus with a club foot. I'm not going to pretend that I'm sufficiently au fait with the detail to see whether there's any nuancing of that within the observations of the committee. But certainly that isn't how the attorney interprets it. And then the final point on the UNCRPD is a point made by the Centre for Reproductive Rights, who deal with this in their intervention. That's in the intervener's additional documents at supplementary MS, and the written case starts at MS 31, and they deal with this issue at MS 51, paragraph 57. And they refer to the attorney's argument, make the point in the middle of paragraph 57 that it would be a significant departure from international human rights law and jurisprudence, wholly unprecedented interpretation of the ECHR. No adjudicative body recognises the right to life applies prenatally. And then they say, moreover, the AG has not and cannot show any authority for his proposition at paragraph 92, that's the paragraph I referred your ladyships to a moment ago, that the reference to human being in Article 10 was intended to apply pre-birth. Indeed, the same language appears in Article 6 of the ICCPR, and the ICCPR Travaux Préparatoires confirm this was intended not to apply prior to birth. Neither was the language in the preamble of the Convention on the Rights of the Child intended to preclude the possibility of abortion. And you can see that the centre makes good that point in the footnotes. So that's the UNCRPD. I turn finally to the topic of Article 14. And I'm always rather sad in this case that every time I've presented it, Article 14 is the point that gets squeezed at the end. Because in my submission, what this case is really about is discrimination against women and the treatment of women and girls. Now, it is true, it's difficult to pinpoint that discrimination because, of course, only women get pregnant. But at the heart of this case is the fact that Northern Irish abortion law fundamentally fails to respect women and to treat them as women in a way, and treats them as women in a way that is wholly unjustifiable. And I don't think I need to spend long on making the point that in the case of discrimination where you're dealing with something to do with pregnancy, it'd be wrong in principle to have to go out and somehow create some false male comparator. But trying to look at the discrimination here, in my submission, the starting point is that the degree of intrusion into women's autonomy is extreme, both in terms of criminalisation and in terms of denial of healthcare. And there is no situation in which a man faces criminal sanction for making a choice about his bodily autonomy which is plainly in his best interests. And there's no situation in which a man is denied his healthcare choice by reason of other people's morality. He might be denied his healthcare choice because it's expensive, but not because somebody else says it's against their morality. And in terms of support for the discrimination argument, the CEDAW committee, as we've already seen, have made it plain that they view interfering with women's access to reproductive health services as discrimination. And if I can just give the court the reference, our case, paragraph 175. But also, the UN Human Rights Committee, which upheld the complaint of Miss Mellett, dealt, in the opinion of Professor Cleveland, with discrimination. And I would like to take the court to this. So Mellett is Authorities Bundle 15 at tab 144. MS 5388. And paragraph 7.11 this is the committee's conclusion, and it finds at 7.11 MS 5387 that there is discrimination. Top of 5388, committee notes the author's claim that Ireland's criminalisation of abortion subjected her to a gender-based stereotype of the reproductive role of women, primarily as mothers, and that stereotyping her as a reproductive instrument subjected her to discrimination. The committee considers that the differential treatment to which the author was subjected in relation to other similarly situated women failed to adequately take into account her medical needs and socio-economic circumstances and did not meet the requirements of reasonableness, objectivity and legitimacy. Accordingly, the committee concludes the failure of the state party to provide services to the author that she required constituted discrimination, violated her rights under Article 26. And as far as Professor Cleveland's opinion is concerned, that's at MS 5390, and she deals with discrimination in a bit more detail at 5391, paragraph 7. And I am going to take the opportunity to read this.
But I know you're very short of time now. You seem to be commuting between comparing women to men and comparing Northern Irish women with English or other women.
No.
Should you not be pinned down?
My Lord, 2 points. I'm not comparing Northern Irish women to English women.
Or not?
No, absolutely not. That's not the basis of the comparison I seek.
Well, there isn't time to look at it, but paragraph 173 of your case did do that.
Oh, I'm so sorry, my Lord. There was a point up until yesterday, yesterday, about the differential treatment of Northern Irish women because of the cost, primarily, cost of coming here to get an abortion. But thankfully, the government yesterday made its statement, and although there is still an issue there, it's a pretty, compared to what's really going on in this case, it's a pretty marginal issue by now. So I'm not going to push that one.
Very well.
Now, but in terms of your lordship's other point, my submission, when it comes to discrimination against women who are pregnant, it's very clear in the EU context that you don't need a comparator. That's the Saint-Prix case we refer to. But in the convention...
Sorry, how can you discriminate without a comparator?
Right.
Well, because you are not respecting the fundamental nature of the woman.
No, but that's a breach of the basic convention. At the moment, I would have thought discrimination by definition means by comparison.
Well, my Lord, you can't find a comparator to a pregnant woman in the sense that men don't get pregnant and it's a unique status. Pregnancy is a status of its own. And plainly, the justification being advanced here, which is around the protection of the fetus, it would be a completely false analysis to try to find a comparator because men don't get pregnant. So the only logical answer to that is, well, you can't be discriminating.
Well, anyway, I mean, this committee you just referred us to found a comparator. The discrimination it found was as between women receiving other medical care during a pregnancy which they wanted to run to term, and women who want an abortion. That was their comparator. I don't know whether you're advancing the same one or not.
My Lord, I would say that the better comparator, the better analysis is that set out in Professor Cleveland's opinion at paragraph 7. So rather than trying to compare the woman who wants an abortion with the woman who doesn't want an abortion, compare the respect for women as opposed to the respect for men. So the comparator is a man, but not in the sense that a man is pregnant. It's a respect for women's personal autonomy and integrity. Paragraph 7, MS 5391. Modern gender discrimination is not so limited. The right to sex and gender equality and non-discrimination obligates states to ensure that state regulations, including with respect to access to health services, accommodate the fundamental biological differences between men and women in reproduction and do not directly or indirectly discriminate on the basis of sex. They thus require states to protect on an equal basis, in law and in practice, the unique needs of each sex. In particular, as this committee has recognised, non-discrimination on the basis of sex and gender obligates states to adopt measures to achieve the effective and equal empowerment of women. And that, in my submission, is a good way of putting it. So it's a positive respect. It's almost, although I always struggle with this a bit, a thalamnos type
Well, I was wondering about
situation.
that. Yes.
I know
because
it's
they're different, you have to treat them differently.
Yes. You don't try and find a man who's like a woman. You say treat a woman with the degree of respect you would treat a man. And that's what Northern Irish law doesn't do. So, in my submission...
I mean, it does seem to me it comes back to the basic question that there should surely be a degree of similarity between the conditions in order to say that there's discrimination, and if men can't be pregnant, there's a problem.
Well, it's a problem that the Court of Justice of the European Union solved a very long time ago.
Sans prix.
I didn't know that was within their powers, but...
Yes. Well, there are two answers, aren't there? One is the European CJEU solved the problem in sans prix, web and emo. You don't need a comparator.
Emo, a lot more.
Yes, emo.
Yeah.
But the other is, yes, it's insoluble. Men don't get pregnant. You can't.
Sorry, what's the authority if you don't need a comparator?
Web and emo, my lord, which I think we cite in our case.
You
do. Very long-standing case in EU law about not needing a comparator.
Discriminating against pregnant women is discriminating against women for the purposes of the treaties.
Yeah.
I think.
Yes, absolutely.
And you don't compare what you would do with a pregnant woman with what you would do with a sick man.
Yes.
Because pregnancy is not an illness.
Yes.
Except sometimes.
So just finally, because I know Miss Rose, I'm cutting into Miss Rose's 20 minutes, but I will only do that so for a few seconds. Oh, I can't.
Just give us a reference in your case to web and email. At any rate.
David, while Mr. Blundell's finding that, justification, the other side of the balance, effectively the same as Article 8, but just for the purposes of the Article 14 analysis. Firstly, this is discrimination on the basis of gender, so it's a suspect ground. Secondly, very severe impact. Thirdly, the burden of justifying the justification is on the respondent. Fourthly, there is no justification because the only argued justification is the saving of the fetus, and it's not saving the fetus. And the web and emo reference is it's authorities 138, but we'll just have to find the number. And it's our paragraph 172 of our case.
Thank you.
Yep. Sorry.
Thank you, Ms. Leven. I shall make the assumption that your next junior does not wish to follow.
Yes.
Ms. Rose.
My ladies, my lords. The seventh intervener is the compendious term for a group of reproductive rights organisations. Our written case is in the supplementary interveners bundle behind the tab that's labelled seventh intervener, and it's MS 1814 in the supplementary MS. Of course, we stand by everything we say in our written case, but today I wish to focus on one issue in particular, and that is the question of the importance of the principle of autonomy, self-determination, personal choice. In our submission, the right to personal autonomy, which is an aspect of the right to dignity, is relevant in three ways in this case. First, it's relevant to the question whether the minimum threshold has been crossed for there to be inhuman or degrading treatment for the purposes of Article 3, because treatment, which is a serious interference with human dignity, can cross the Article 3 threshold. Secondly, we say it is intensely relevant and important to the balance that is to be struck under Article 8 between the rights of the woman and the legitimate aim being pursued by the state. And in particular, we say is relevant to the question of fair balance under Article 8. And finally, it's also relevant to the question of justification for discrimination. We submit it's instructive to see how the Attorney General, in his written case before this court, has chosen to present the position on fair balance. And if we can just take up the first core volume, the case for the Attorney General at page MS 8704, and it's paragraphs 79 to 81. And what he says, in the context of Article 8, is that the legitimate aim of the criminal provisions is the protection of the unborn child's life to the extent possible without significant and enduring damage to the life or health of the mother. And then at paragraph 81, when discussing Lord Justice Wetherup's judgment, he says halfway down the paragraph that this ignores that the balance struck does not purport to afford absolute protection to the unborn child. The balance is struck in favour of the mother's life and health, with the public interest in the protection of life before birth giving way when, and only when, the impact on the mother reaches the level where a threat to the life of the mother or serious and long-term threat to her health can be established. And they say where that impact is not serious or not long-term, the unborn child is absolutely protected. So as the court can see, the Attorney General there presents the balance as purely being between the protection of the unborn child's right and the prevention of significant and long-term damage to the life or health of the woman. And in our submission, that analysis is fatally flawed because it treats the woman as purely passive. And I use the word passive here in two senses, both in the sense that she is not active and in the sense that it is her destiny to suffer. The only question which the legislation and which the Attorney General treats as relevant to the issue of proportionality and fair balance is whether the woman can continue to live without significant long-term physical or mental damage. If she's alive and she's not a physical or mental wreck, the fair balance has been achieved, according to the Attorney General. And indeed, his analysis, we submit, is consistent with the legislation. That analysis fails to consider at all, or to attempt to weigh in the balance, the effects of the legislation at issue on a woman's right to self-determination, autonomy and choice, in a context that will affect every aspect of her future life, regardless of whether her physical or mental health suffers long-term significant damage. Putting it simply, forcing a woman to bear a child against her will is a serious interference with her rights, whether or not her life continues and whether or not she becomes a physical or mental wreck. That interference cannot be left out of account when the court considers whether the fair balance has been struck. This point holds good in relation to all three of the categories of case that are before this court, and the court will have been moved, as I was, by the account of the evidence this morning about the appalling impact on the women who have given evidence in this case of the denial to them of choice and the forcing upon them of an intolerable compulsion. But I want to focus particularly on the cases of pregnancy resulting from rape or from incest, and in particular the sexual abuse of a child, which is of course what most incest is. Rape and sexual abuse are in themselves profound invasions of a woman's right to autonomy and to physical and mental integrity. The impregnation of a woman by forced sexual intercourse compounds the severity of that invasion to a very severe degree. For the state then, in that situation, to deprive the woman or the girl of the right to take back control of her own body, to force her either to bear the child of her abuser or to leave the country and undergo the risks of criminalisation and the other adverse effects we have encountered, but to force her to bear the child, to be a mother to that child, with all that that implies, is the grossest violation of her rights to autonomy and physical integrity that can be imagined. The immorality, the unfair burden of refusing to a woman or a girl in that situation the right to choose to terminate her pregnancy does not depend on her individual mental robustness. The woman who eventually recovers from the distress and trauma to which she has been subjected has had her rights violated just as assuredly as the woman who is left a long-term mental wreck. We submit that this analysis is fully supported by the case law. Our courts recognise that physical and mental integrity and personal autonomy, including the right to choose what medical treatment a woman will or will not have in her own best interests, and to choose whether or not to be a parent, are recognised as fundamental rights protected both by the Convention and by the common law. We submit that those rights must be taken into account and given their full weight when the Article 8 balance is undertaken, and that a sufficiently serious interference with them may cross the Article 3 threshold. As is so often the fact, in this case, as in many others, the common law has developed in dialogue with the Strasbourg Court. My time is very short. I simply want to flag the relevant authorities. The first is the case of S against St George's Hospital. That's volume 26, tab 255. A case of a mother who was told that her child's life would be endangered if she did not consent to a caesarean section. She refused to consent to a caesarean section. And in particular, if the court looks at pages 43 and 46 to 50, there is a detailed discussion of the importance of the right to autonomy. The woman has an absolute entitlement to refuse the caesarean section, even if it kills her baby at the moment of birth. And the reason for that is that at common law, her right to self-determination is paramount, and it is an assault to subject her to a caesarean section, even if that would be necessary to save the life of the baby. And in my submission, this is an answer to the point that my Lord Mance was putting to Ms. Leven this morning about the question of the relevance of the rights of the child. The common law here recognises that in this situation where you're looking at invasive medical treatment, because of the seriousness of the interference with the right to self-determination, even if the child will inevitably die, the mother has the absolute right to refuse medical treatment. And that is because of the effect upon her, the degradation of her individuality, of forcing her to undergo medical treatment.
This is a pure common law case.
Yes, it is, my lord. Then the case of Parkinson and St James, that's a case in the Court of Appeal. It's at volume 8, tab 68. It's a wrongful birth case where there was a negligent sterilisation, and as a result, a woman gave birth to a child that had disabilities. And the question was whether she could be compensated for the additional cost of bringing up a disabled child when she had not wished to have any child. And Lady Justice Hale, as she then was, paragraphs 56, 58 and 66 discusses the principle of bodily integrity and describes it as the first principle of the law of tort, and the right of autonomy to choose what happens to your own body. This is a very powerful common law right described by Lady Justice Hale in that case. The baton is then taken up by Strasbourg. The case of Tysiak and Poland, it's in 2007. This is volume 4 of the authorities bundle, tab 25, MS 1297. This is a case of a woman who suffered from severe myopia and was concerned that if she gave birth, her eyesight would be severely damaged and wasn't given proper advice. And at paragraph 109, page 1319, the court says that when you are conducting the Article 8 balance in this context, the woman's right to personal autonomy must go into the balance. And we submit that there you see Strasbourg adopting a similar approach to the approach of the common law. The same point is made in ABC in Ireland. My Lord Reid earlier referred to paragraph 232, where the interests being balanced were summarised by the court. Can I invite the court to compare 232 with 212? Because at 232, the court simply refers compendiously to the woman's right to private life. But if you see what is meant by that at paragraph 212, the court makes it clear that that includes the right to personal autonomy. And we see the same thing in PNS in Poland. That's volume 3, tab 20, MS 1100. And in particular, paragraphs 96 to 97 imposing a positive obligation on the state to enable the effective protection of rights to physical and psychological integrity and autonomy. We then come back to the United Kingdom, where the Supreme Court, in the case of Montgomery and Lanarkshire in 2015, that's volume 8, tab 66, MS 2637, considered a situation where a woman was not warned about the risks to her of a vaginal delivery because the doctor thought that a vaginal delivery was in her best interests and didn't warn her of the risks, and as a result, the baby was born severely disabled. And the leading speech is given by Lord Kerr and Lord Reid, and at paragraph 80, that's page 2668, that cites the decision in Tissiach, and as a source for the importance of the right to self-determination, which is then taken up again at common law. In the same case, Lady Hale's concurring judgment, paragraphs 108 and 114 to 116. And there Lady Hale stresses the fact that pregnancy does not remove the right to be treated as an autonomous human being. And finally, in the case of A and B in the Secretary of State for Health, volume 1, tab 5, MS 281, Lady Hale at paragraph 93, stressing that autonomy and equality are both aspects of human dignity. And that takes us back to the Article 3 violation, because the European Court of Human Rights made the point in Pretty, that's volume 3, tab 21, paragraph 52, that treatment that shows a lack of respect for human dignity may be degrading treatment. So in summary, our submission is a simple one, that the Northern Irish law is defective, not only for the reasons identified by Ms. Leven, but also because the criterion that is applied in order to determine whether an abortion is lawful, namely preserving the woman's life, as broadly interpreted in Bourne, entirely leaves out of account the importance and the weight to be attached to the woman's right to autonomy, to control and to choice. A woman who has been raped has the right to refuse to bear a resulting child without having to prove to a doctor that if she does, she will be a long-term mental wreck. Requiring her to undertake that task of proof on pain of criminal sanction is an intolerable affront to her dignity as a human being, which violates her rights under Article 3 and also under Article 8. The Northern Irish law is a disproportionate breach of her rights because it fails to acknowledge, to accommodate, or to respect that right and take it into the balance at all. The exclusive focus on the preservation of the mother's life and, in the most basic level, her mental and physical health is inherently disproportionate. In short, the flaw in the Attorney General's submission reflects the flaw that is inherent in the legislation itself. I'm sorry it was so rushed, but if I can be of any further assistance, I will try to be.
Impeccable timing, Miss Rose. You totally well done. Thank you. Ms. Gallagher.
My ladies, my lords, I appear on behalf of Humanist UK, the first intervener, with Ms Fiona Murphy, Ms Mary Rachel McCabe, instructed by Janet Farrell of Bat Murphy. Humanist UK rely on 4 documents, which are short, contained in 2 places. Firstly, our written case, which can be found at the intervener's additional documents bundle, commencing at supplementary memory MS page 3. And secondly, 3 witness statements prepared by eminent moral philosophers who are supporters of the charity, Professors Simon Blackburn, John Harris and A.C. Grayling. And they are contained at Core Bundle 5 behind the tab marked Intervener 1. MS 10280 is the starting point for those. Following on from Ms Rose's submissions, the witness statements focus on reproductive liberty and the suffering of women and girls, and they derive from the essential dignity and rightful autonomy of human beings. And those statements really provide some of the philosophical moorings to the jurisprudential submissions by Ms Rose on autonomy. Before I start my submissions, I'd like to tell you the route I propose to follow, given that I have very little time to cover much ground. So as to route, I intend to address 3 topics. I have 30 minutes, so it's approximately 10 minutes per topic. So it's going to be quite a canter, as indeed it was for Ms Rose. Firstly, I'll briefly make some supplementary submissions on 2 core points which underpin the case against the appellant and show that they are flawed. And these will be additional to the points made by Ms Leven. They are firstly the lack of an evidential basis for the loosely termed moral case, and secondly, the inaccurate suggestion that the fetus is a rights holder, some additional points as to why that's wrong. Secondly, I'm going to address Article 3. Humanists UK fully support the case on Article 3, which has been put forward by the appellant, but we're going to make some supplementary submissions on a specific point, which ties in with a question from my Lord Kerr earlier. And that is about what we say is a specific positive obligation arising under Article 3, a systems obligation in relation to those pregnant as a result of sexual violence. We'll draw on the international material to show why we say there is such an obligation. And then thirdly, I'll address Article 8, and I'm going to highlight 2 points. The respondent's failure to pass what we say is the first hurdle under Article 8.2, concerning whether the gross interference with the rights of women and girls in this case is in accordance with law, and secondly, the lack of evidence, necessity or proportionality for that interference in the particular categories. For speed reasons, where possible, I intend to provide the references to the authorities and the evidence without necessarily turning them up, but please do stop me if you need to turn them up and ask any questions. So firstly, these 2 underpinning points. We want to look at A, the lack of evidential basis for the moral case, and then B, the fetus not being a rights holder. So on the lack of evidential basis for the moral case, the case from the Commission, the case against the Commission from the respondents and the opposing interveners, and indeed the language of the Court of Appeal, relies on a generalised purported justification concerning the bar on abortions in all but the narrowest of circumstances, based on very loose language, referring to, for example, in the Attorney General's case at 119, the political and moral judgment of Northern Ireland, or, in the words of Lord Justice Gillen, the protection of morals and or the unborn child, running together, as Ms Leven pointed out, those 2 quite separate issues. And we say there's a very thin evidential basis for this for a number of additional reasons supplemental to those outlined by Ms Leven. First, the Department of Justice asserts in its case that the 1861 Act follows the conceptual framework of Vaux in France and reflects Article 2 protections for prenatal life. Now, Ms Leven's explained why that's a misunderstanding of Vaux in France, but there's also not a proper evidential basis for suggesting that the 1861 Act was focused on protection of prenatal life at all. And there's 2 strong historical points on this to be found in Roe and Wade, that's volume 28, tab 294, MS 1695. And the 2 points made there are, A, the relatively recent vintage of abortion laws, with women having much wider choice in reproductive rights terms until the latter half of the 19th century. That's particularly at MS 1711 and 1722 to 23. And that draws on the common law material, the underpinnings of the common law material, which Ms Rose has referred to in her submissions on autonomy. And B, the fact that when these laws were brought in the latter half of the 19th century, the abortion procedure was hazardous for a woman It was prior to the discovery of antiseptic techniques in 1867. Abortion mortality was high, and in fact, a core concern was the protection of the woman rather than prenatal life. It was an inherently hazardous procedure, and on that see MS 1730 to 31. Now, whilst we don't have definitive evidence either way before us on the papers here, there's at least some material casting doubt on the presumed moral case underpinning the 1860 Act. And second, as has been pointed out, heavy reliance has been placed on the finding by the European Court of Human Rights in relation to ABC in Ireland, that the law in the Republic of Ireland, in relation to the law in the Republic of Ireland, and some supplemental points in addition to misleading submissions which we fully support. A, that case doesn't find that a bar on abortion is necessarily justified in convention terms. It was very focused on the law in Ireland and its underpinnings. And the Department of Justice assertion at paragraph 108 that Northern Ireland and Ireland are conceptually identical is simply not correct. Now, that's partly because of the 1983 referendum, universal suffrage referendum, resulting in a clear statement of the Irish public's views. But there were also two further referendums in 1992 and in 2002, both referred to in A, B and C, and an express reference was inserted into the Maastricht Treaty on European Union in 1992 to preserve the Irish constitutional position. And there have simply been no such processes in Northern Ireland, and it is wrong to describe the positions as conceptually identical. And of course, there will be a fourth referendum shortly. It's been announced next summer. B, in any event, as the successful case of C showed, the combination of a bar to abortion in one's home country, combined with difficulties in respect of travel, may indeed result in a breach of the convention in any event. And C, the approach adopted by the European Court of Human Rights to the question of justification in a different context concerning Article 10 in the Open Door case, we say, is also instructive. Now, despite the voluminous bundles, the Open Door and Well Woman case wasn't in them. So we've provided a hard copy over lunch in light of some of the questions which came up earlier. And that is 1993 15 EHR 244. And there, so that concerned provision of information to women about travel for abortion abroad. And the European Court of Human Rights rejected the Irish government's submission that the court's role of review in such a case concerning the protection of morals was extremely limited, noting that whilst there was a wide margin of appreciation, it's for this court, in this field also, to supervise whether a restriction is compatible with the convention. And that's at paragraph 68, and that ties in with the question, I think, earlier from Lord Mance about moral views and the weight to be given to them. And the court says that to adopt the light touch, extremely deferential approach to government policy suggested in that case would be, and this is a quote from paragraph 69, an abdication of the court's responsibility. And when you look at paragraphs 76 and 77, it's on page 267 of the report, the court did look at the NIMBY point, if I can put it this way, the issue that was discussed earlier with Lord Reid regarding the fact that women travel, and one of the quotes which is used by the Campaign for Reproductive Rights in Northern Ireland is not at all, just not here, that it happens anyway. And there's a lack of evidence to show that, in fact, abortions are stopped, save in the tiny number of very extreme, distressing cases like the Ashley Topley case. And paragraphs 76 and 77 deal with this. And the court said, when examining whether there was a pressing social need for the restriction, and in particular whether it was proportionate, the fact that large numbers of women were still obtaining abortions in Great Britain undermined the policy imperative advanced by the government. That's at paragraph 76. And also at 77, they said that the impugned measure in that case, restricting the provision of information, in fact created a risk to the health of those women who were now seeking abortions at a later stage in their pregnancy due to lack of proper counselling, not availing of customary medical supervision after the abortion has taken place. And moreover, they said, the injunction may have had more adverse impacts on women who were not sufficiently resourceful or had not the necessary level of education to have access to alternative sources of information. And these are legitimate factors to take into consideration in assessing the proportionality of the restriction. And similarly here, those factors are very relevant in a Northern Irish context when we look at balance under Article 8. The next point I wanted to deal with under topic 1 concerns the fetus as a rights holder. Now, the respondents and a number of the interveners characterise the fetus as a rights holder in human rights terms, protected, they put it in various ways, under Article 2 of the Convention, the CRPD, or indeed the UNCRC. And Ms Leven has dealt comprehensively with the Article 2 issue and VO and the CRPD. But there is also the UNCRC argument, which we say similarly is entirely flawed. Precious Life and the bishops argue that Article 1 of the UN Convention on the Rights of the Child, which states that a child means every human being below the age of 18 years, unless the law applicable to the child majority is attained earlier, has no starting point, and therefore human being may incorporate pre-birth life. And the references for that are at MS 9268 and in the supplementary interveners bundle at MS 53. And particular reliance is placed on the phrasing of the preamble of the UNCRC at paragraph 9, which refers to protection before birth. But the position is this, put very simply. Since 1989, and indeed since 1991, when the UN Committee on the Rights of the Child commenced its work, in that quarter century, the committee has never stated that the fetus is a rights holder pre-birth, has never criticised overbroad abortion laws, and in contrast, has relatively regularly criticised restrictive abortion laws that force adolescent girls to undergo unsafe abortions. And in fact, in its general comment 4, which is at volume 18, tab 184, MS 6361, it called on states to develop programmes that provide access to safe abortion services for children. Now, that is in the context of the Supreme Court having made clear that the UN Committee on the Rights of the Child's analysis of the UNCRC is authoritative guidance. You were taken to that earlier by Ms Leven. That was the phrase of Lord Carnworth in SG at 105 to 106, and the reference for that is Core Authorities 2, tab 11, MS 742. And that, of course, was cited with approval by my Lord Wilson in the Matheson case at 39 to 40. That's Core Authorities 1, tab 4, MS 274. There's additional points against it, but we say that's a clear answer as to why this is just a bad point. The Department of Justice also mischaracterises the issue before the court at Core 1, MS 8614, paragraph 88, stating, the Grand Chamber in Vaux was clearly resistant to the suggestion that it should seek to locate or consolidate some emerging consensus among European states as to when life begins. That's precisely the exercise which the appellant invites the court to adopt in the present case. And that is nonsensical. The appellant plainly does not, and neither do Humanists UK, invite the court to decide such a question. And as Justice Blackmun put it in Roe and Wade at volume 28, tab 294, MS 1741, we need not resolve the difficult question of when life begins, when those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus. The judiciary, at this point in the development of man's knowledge, is not in a position to speculate as to the answer. And our submission on behalf of Humanists UK is that the court can and should acknowledge that there is a looser, valid claim to there being some value in potential life without accepting that life begins at conception or at some other particular point. And that reflects what's acknowledged in Vaux at 84, the potentiality of that being and its capacity to become a person, or indeed in Roe and Wade at MS 1732, which says a legitimate state interest need not stand or fall on acceptance of the belief that life begins at a particular point. And you can still give recognition to the less rigid claim that when potential life is involved, there may be some interest. Now, that is very far from recognising that a fetus is a rights holder in convention terms, or that there is a right to life involved in human rights terms. There is not. This is a much looser and weaker countervailing value, irrelevant in Article 3 terms when looking at the negative obligation. We accept, in answer to a question earlier about absolutism, that when we turn to the positive obligation under Article 3, it is a relevant factor, but we'll show you why we think it's outweighed. And it's to be given very limited weight in the balancing exercise under Article 8, and particularly limited weight pre-viability, and minimal, if any, weight in FFA cases where there's no such potentiality at all. And that submission is underpinned by the evidence of Professor Blackburn on potentiality at Core Volume 5, MS 10290, at paragraphs 9 to 12. where he explains why a newly fertilized ovum is not a person, it's a ball of cells, and there is simply no metaphysical argument to support the idea that such a structure has rights, let alone the rights that belong to a grown, sentient, self-supporting creature. And he highlights that it's easy to forget these realities by using the language of the rights of the unborn child. But a blastocyst is not a kind of child. It's no more a child than an acorn is an oak tree or an egg is a chicken. It's something that may become a child, and then, but only then, bear children's rights, just as an acorn may or may not become an oak tree, or an egg may or may not become a chicken. And he's got the very powerful reference to how it would be incorrect to say that a lonely house by the Thames in the Bronze Age became the City of London. All that should be said is that a continuous process of growth has led to there now being a city where once the house was, and we rely on that. So there is a countervailing value, but it's a relatively weak one. Topic 2, and I'll race through this.
That's ultimately a submission, isn't it? I mean, it's ultimately a submission because who have rights are decided by courts.
Yes.
There isn't such a thing, unless you derive it from a religion, there isn't such a thing as a truth about what a right is or indeed what a person is. It's a matter of definition by courts.
No, but when you look at how the European Court of Human Rights has approached it, or when you look at the international bodies have approached it, we're not aware of a single instance in which the fetus is recognised as being a rights holder in human rights terms. So it is a submission, but it's a rebuttal submission. On the second point in relation to Article 3, we wanted to address the system's duty and the positive obligation, 2 separate points. Firstly, I'm going to race through the international framework of relevance, and then I'm going to turn to why we say there's a breach here of the system's duty in addition to the duties which Ms. Leven has dealt with, and we entirely agree with and support her submissions. So on the international framework, we deal with that in our written case at 3.3 and 3.6 to 311. It's on supplemental memory stick at page 7. And we address gender-based violence there. And similarly, the UN and the appellant also refers to this in relation to the Article 7 positive obligation mirroring Article 3. There are 2 critical international documents which we wish to rely on in this context, in addition to CEDAW and Article 7, and they are the Istanbul Convention and General Recommendation 35 of the CEDAW Committee. The Istanbul Convention is contained at Volume 27, Tab 274, MS 1475. And in summary, it acknowledges that violence against women and girls is gender-based discrimination, necessitating positive action by state bodies to address the adverse effects of such violence. And it doesn't draw on a comparator to do that. It reflects the statistical position, which is that the prevalence, impact, and consequence of violence against women, including sexual violence, is very different to that against men, and that women and girls are much more likely than men to be the victim of multiple instances of abuse, in particular of sexual violence, and they're significantly more at risk of serious sexual assault, 1 in 20 women compared to 1 in 331 men. The purposes of the Istanbul Convention are set out in Article 1, and they include not only to prevent, prosecute, and eliminate violence against women, but importantly, to design a comprehensive framework, policies and measures for the protection of and assistance to all victims of violence against women and domestic violence. And there's a specific series of obligations. Article 6 places obligations upon the parties to develop gender-sensitive policies. Article 18 sets out obligations in relation to supporting victims and having a gender-sensitive approach. Now, in our submission, and also I should mention Article 18.4, which requires the provision of services that are not dependent on an obligation to testify where there's been sexual violence. Now, gender-based sexual violence includes child sexual abuse, sexual assault outside an intimate relationship, teenage physical dating violence, and intimate partner violence. And those latter 2 categories encompass abusive unions. And it's now very well established, we give the references in our written case, that abusive partners may try to manipulate reproductive outcomes as part of their efforts at control, from sabotaging contraception to physically assaulting pregnant women with the aim of inducing miscarriage, and indeed preventing women from having abortions. And that was dealt with very powerfully in the evidence from Client B by Dawn Purvis in particular. And adolescents are particularly at risk, and a number of studies which we've cited in our case indicate that a very high percentage of rapes occur at a young age, and that chimes with the evidence of Les Allenby and the statistical evidence to which you were taken by the appellant earlier, which shows that when you look at the victim profile for reported sexual offences, 56% were children, were under the age of 18, and that's MS 9068. And the concomitant risk for victimisation in those circumstances, an unwanted pregnancy, highlights, we say, the need to understand and acknowledge the role that gender-based violence may have in abortion. The Istanbul Convention came into force in 2014. As of a number of months ago, the United Kingdom government is committed to ratifying it, having passed an act to that effect, which you can find at volume 24, tab 124, and its supplemental MS 121. And it provides a timetable for that. The second document, which goes further, is General Recommendation 35, and that's at volume 18, tab 178. And if I could ask you to turn that up, it's MS 6271 is where it starts. I just wanted to take you to a number of paragraphs in that general recommendation. It's paragraphs 17 and 18, which are on MS page 6276.
So what volume did you say it was again?
It's MS 6276. The hard copy is volume 18, tab 178.
Paragraph?
Paragraphs 17 and 18.
Thank you.
So paragraph 17, it refers to the need for a gender-sensitive approach. Paragraph 18 is critical because paragraph 18 says violations of women's sexual and reproductive health and rights, such as forced sterilizations, forced abortion, forced pregnancy, criminalization of abortion, denial or delay of safe abortion and post-abortion care, forced continuation of pregnancy, and a number of other matters, are forms of gender-based violence that, depending on the circumstances, may amount to torture or cruel, inhuman, or degrading treatment. And the footnote then cross-refers to Mellett and Whelan, which I understand Ms Mountfield will deal with in more detail on Thursday. And at EU level, reflecting General Recommendation 35, gender-based violence is acknowledged, as is the need for additional support, services and protection. And if I can just give you the cross-reference to a particular document in our case. So in our case at paragraph 3.11, which is supplemental MS 11, we referred to a recent European Parliament motion concerning the Istanbul Convention, which said that forced pregnancy is a serious crime, a serious form of gender-based violence, and it calls on member states to guarantee comprehensive sexuality education, full range of reproductive and sexual health services. Now, following on from that, our submission is it's highly material that among the categories of women and girls with whom this appeal is concerned are those seeking access to abortion services in the context of their existing victimhood, and specifically as victims of treatment contrary to Article 3 already in the form of rape or incest. And in those contexts, the operation of state control over matters of personal autonomy runs a particular risk of infringing their rights under Article 3. And the systems breach is, we say, a little different to the negative absolutist breach, which has been referred to and been the subject of questions earlier. This court is obviously familiar with Article 3's positive obligations in the sense of an Osman-type obligation or a systems-type obligation when you are looking at a protective obligation prior to an Article 3 violation taking place. The situation here is different because the woman or the girl has already been subjected to Article 3 violative treatment by a third party, and the issue is the state's consequent obligation, in light of her existing victimhood, to protect her from the continuing impact of that sexual crime that they've suffered, dealing with the fallout, if I can put it that way. And my Lord Kerr, in a question earlier concerning MC in Bulgaria, highlighted it, referring to the systematic deficiency. In that particular case, the systematic deficiency was that resistance had to be established. But as it was put by my Lord Kerr, it doesn't matter what the deficiency recognised was. The key issue there was that vulnerability was a prominent feature. And we say that the Northern Ireland State's positive duty is to put in place a framework of laws that, echoing the language of Rabone and other cases, to the greatest extent reasonably practicable, protects women and girls from Article 3 violative treatment, and that the Northern Ireland legislative arrangements are in direct and irreconcilable conflict with that positive duty. And we highlight two particular features which are recognised in the Article 3 case law, and they are vulnerability and discrimination. So on vulnerability, if I can give you the reference to the Alberte case, Alberte in Latvia, which is in volume 26, tab 263. Can you get me the MS page? And that shows the legal significance of vulnerability under Article 3. It shows it's a relative assessment involving considering the victim. And that's a situation where there was the removal of tissue from the body of the applicant's deceased husband without her knowledge or consent. And the court there found there'd plainly been a violation of the negative duties protected by Article 8. But given her particular vulnerability, something which would otherwise have been a breach of the Gascon-type obligation under Article 8 became an Article 3 breach. And I should say the MS number is 1091 for those of you working electronically. And there's obvious parallels with the cohort of women and girls who conceive as a result of sexual violence. The state has special affirmative duties to them, see Istanbul General Recommendation 35. And there, something which might otherwise be Article 8 becomes Article 3. And similarly, in relation to discrimination, can we just give you the reference to the Identoba case, which is dealt with in our case? That's volume 29, tab 26. And it's at MS 10290. And that highlights that where you have a discriminatory element, that's also relevant to the Article 3 assessment. And in our submission, the fact that those who are pregnant as a result of rape or incest are victims of gender-based violence and discrimination already, they are pertinent factors. Their vulnerability and the discrimination are pertinent factors. Here we say there's a number of special characteristics which mean that there's a breach of Article 3. We've summarised it in our case. Just very briefly, in the, I think, 4 minutes remaining.
3.
3. On the final issue about Article 8. Firstly, in accordance with law, we deal with this in our case. In our submission, there's a number of reasons why the Bourne exemption and its parameters are insufficiently precise to have the necessary quality of law. Firstly, there's uncertainty at the highest level in the courts in Northern Ireland. Despite the purported clarification of the Bourne exemption in 2005, 3 justices of the Northern Ireland Court of Appeal were not able to reach agreement on its application. Morgan LCJ held at 79 that the Bourne exemption would encompass the categories in issue in this case. Neither of the other justices agreed with them. This is simply not a matter grappled with by the Attorney General in his case, and one to which we say there's only one answer. The current law does not meet the standard of clarity required by the Convention. Secondly, there's a mismatch between the submissions of the respondents and the reality of the current situation in Northern Ireland. See the submission that Sarah Ewert's case could have fallen within the Bourne exemption, despite everything that she did to attempt to have an abortion and failed. And thirdly, there's evidence to the effect that medical professionals in Northern Ireland are afraid to administer abortions under the Bourne exemption. There's a chilling effect, and that's, we can give you the reference to Dawn Purvis at paragraph 12, Sarah Ewert at paragraph 19. And then the final point concerns Article 8.2 and necessity proportionality. And in our submission, the profound and particularly intrusive interference with a woman's fundamental rights to autonomy, self-determination and dignity is relevant when conducting the close and penetrating examination that's required under Article 8.2. And we make 2 key points as to why this is not an interference which is necessary in a democratic society. Firstly, the particularly intense nature of the interference. Pregnancy is an all-consuming physical experience affecting how a woman breathes, moves, sleeps, toilets. Pregnancy involves her internal organs being squeezed, her heart must pump faster, her muscles and joints are loosened. And where pregnancy results from sexual violence, the pregnant woman or girl is in an acutely distressing situation with those constant physical reminders of the ordeal. If she carries the fetus to term, she then bears all the emotional and life-changing consequences of an unwanted child fathered by an abusive and potentially dangerous man with whom she may then have an unwanted lifetime connection. And that's taken from Professor Blackburn's evidence. And in FFA cases, there's the stark choices heartbreakingly illustrated by the evidence before you. Second, there's the weakness of the vague moral case which we've referred to earlier. And also on this issue, this ties into a question from Lord Kerr earlier about imposing moral views on others and it having less weight. Here we need to look at the imposition of the moral views on those who have the most extreme vulnerability at this particularly difficult time. In conclusion, Humanists UK are acutely aware of the political sensitivity of this case. As indicated in our written case, we recognise that, as in Bland and Nicholson, there may well be an understandable judicial frustration or unease that these issues haven't been decided by the legislature in Northern Ireland. But in the absence of an exemption addressing the position of the women and girls in the categories before the court, the issues remain justiciable, and because of their extreme vulnerability, it's a vital function of the court to decide it. And we adopt the approach of Lord Hope in Ray G about that. That's Core Authorities 1, tab 2, paragraph 48, commencing at MS 101. This week marks the 50th anniversary of the Abortion Act 1967. For half a century, Northern Irish women and girls have remained without basic healthcare access and protections available to their British neighbours. Their legislature and these respondents have failed to trust women to make their own choices about their own bodies in these dire circumstances of extreme vulnerability. Their legislature and these respondents have failed to act. Now this court must.
Thank you, Ms Gallagher. Thank you to everybody who've got through a lot of material in double quick time. We'll now go and let it all sink in for a while before we go on to the next phase of the argument tomorrow. We look forward to seeing you, those of you who can be here, or must be here, at 10:30 tomorrow. Court is now adjourned.